Hello and welcome to this summary of our 13th annual Employment Law Breakfast Briefing. My name's Ian McRae. I'm a partner here in the Employment Law team at Field Seymour Parks. And essentially this session is a summary of an in-person event we ran in January 2025, summarising some of the forthcoming changes for employment law. So, purpose of this session is really to let you know of some changes that are coming up and ensure that you are ready for them. So what we've done with this session, we've split it into three parts. This is part one. And on this slide, you can see how we've structured it and the different elements that will be covered in the different parts. So in this session, we'll be talking about a couple of cases from 2024 that may mean that your settlement agreement template may need updating. Why the national minimum wage increases for 2025 may impact on employers and may trip up them that are not aware of the implications of it, and also some reasons why organisations are pushing through organisational changes in 2025 ahead of some changes that we are expecting in 2026. You can see what's going to be covered in parts 2 and 3, and please do check those out as well once you've finished part 1. So without further ado, let's talk about settlement agreements. So the reason for including this in this session is that in 2024, there were 2 decided cases on settlement agreements, and in particular concerning the ability to settle future claims. So in simple terms, claims that have yet to arise at the time the settlement agreement is entered into. Now, the first case I want to talk about, which was also the first decided case, is the one of Bathgate versus Technip. And this is a Scottish case. And the facts of it, or the very simple facts of it for the purposes of this session, is there was a settlement agreement entered into with an employee. And within that settlement agreement, it expressly covered and settled claims of age discrimination. The settlement agreement concerned a voluntary redundancy package, and within that there was an additional payment that was going to be made, and that additional payment was going to be calculated and decided under a separate collective agreement. So settlement agreement is all signed off. It subsequently transpires that the employee in this case was not entitled to that additional payment because under that collective agreement they didn't qualify for a payment because they were 61 years old. Employee obviously not happy about it and seeks to bring a tribunal claim. So the case makes its way to the Employment Appeal Tribunal. What they decide there is actually the settlement agreement didn't prevent that case from proceeding. And the reason they did that is that there is a section in the Equality Act, section 147, which basically says that for a claim to be validly settled, then a particular claim needs to be identified. And they said that couldn't be the case here because the claim had yet to come into being, and therefore it couldn't have been identified at the time the agreement was entered into. Now, that wasn't the end of it because it proceeds up to on appeal to the Court of Session, which is the highest court in Scotland. And they disagree with the Employment Appeal Tribunal, and they say actually this was a valid settlement of that claim. And the reason they said that is that they said, yes, section 147 needs to be complied with, but the complaint doesn't have to be known at the time of the settlement agreement, and the grounds for it don't have to be in existence. So a helpful case for employers. It still left, however, some uncertainty. 2 key things really. In one, it was a Scottish case, so not binding on the courts of England and Wales. And the second one, in the Bathgate case, the employee had left his employment. And so therefore there's a question mark is, will it be followed by the English courts? And secondly, does it make a difference if the employee remains in employment and then the claim arises? Well, helpfully, very shortly after the Bathgate decision, we then had this further case of Clifford versus IBM. So this is an English law case, and it was a decision of the Employment Appeal Tribunal. Now, the simple facts of this case is the employee here raised a grievance. They wanted to be part of IBM's disability plan. which, as I understand it, is some form of income protection plan that kicks in when you're unable to work and pays out a certain percentage of your salary. The parties reach a settlement agreement, and as part of the terms of that, the employee does indeed get placed on this disability plan. However, as you've probably guessed, that wasn't the end of the matter, as what transpires is the employee's earnings under that plan did not increase annually in the same way that his salary would have done if he remained in active employment. He then brings a disability discrimination case, and that proceeds through to the Employment Appeal Tribunal, which considers whether or not the earlier settlement agreement was a binding settlement of that future claim. And what the Employment Appeal Tribunal decided in simple terms was that, yes, the Bathgate Scottish decision was correct, and the same approach should be followed in England. And they also stated that continuous employment of Clifford, the claimant in this case, was not necessarily a bar to settling future claims. So essentially, we've got two cases that show that if you are careful, and I'll talk about how you have to be careful, you might be able to settle future claims under a settlement agreement. There are still a couple of key areas of uncertainty. Firstly, Clifford obviously did remain in employment, but wasn't actively working. So there's a question mark if you have someone who's actively working and a future claim arises. Would that lead to a different decision? And also in that Clifford case, there was a very close connection between the reasons and the terms of the settlement agreement and the subsequent claim that arose. It was all related to this disability plan in different ways. If you had something, for example, you had someone who remained in active, normal, full employment, working day in, day out, and they have a claim that it was completely unexpected and completely unconnected to the earlier settlement agreement, would you still reach the same decision? Well, we wait to see as and when a suitable case progresses. Key things then from action points in terms of what this means. Well, you can settle future claims under a settlement agreement, including discrimination claims under the Equality Act, but you have to be very careful in the terms that you do so. And the reason we flagged this up as part of this session is we still see claims, whether acting for employee or employer, that are not drafted carefully enough to ensure you get that settlement of future claims. So you do need to refer in your templates to the either description of the claims that are being settled or a reference to the underlying statute. You need to be plain and unequivocal in the terminology, and you need to ensure there is no ambiguity about your wish to settle future claims if that is what you want within the realms of the settlement agreement. The other things I would say, apart from ensuring that your template is fully up to date, is apply your mind to potential claims. If there are things that you can foresee and you want to ensure they're settled, well, expressly deal with that in the terms. That will make it much easier to ensure that there is a settlement of those claims. And it still will be appropriate to use settlement agreements where there is a second signing or a reaffirmation, which are commonly used when a settlement agreement is entered into, but the employee will remain in employment for a period of time before a termination date in future. You still may want a second signing or reaffirmation there, just because of those areas of uncertainty on settling future claims. It just helps ensure that you do have a binding settlement and that you're not releasing sums of money and then still facing action from an employee. So that was looking backwards, 2024, a couple of cases there. Looking forwards now, and the national minimum wage increases that are due in April 2025 obviously received a lot of publicity. Put the headline key rates on the slide for you. You've got a 6.7% increase for those who are 21 and above, and you've got a larger 16.3% increase for those between 18 to 20. The reason for the discrepancy is that the government is looking to phase out that 18 to 20 rate so that everyone 18 or above will receive the same rate, hence why they are trying to bring those closer together. Now, there are obvious implications of this, increasing financial pressures on employers. Obviously, we've got employer NI increases coming online too. And also, it's not just those on national minimum wage, it may well increase pay pressures for those just above those rates. So maybe your supervisor roles, you will find that you may need to increase those just because of market pressures. To give you some idea of what the new national living wage, which is the top rate of national minimum wage, will mean, well, at £12.21, if you are working 37.5 hours, that comes in at just under £24,000 a year, so £23,809.50. So the other thing I just wanted to highlight, which hopefully I'll use this brief example to do so, is the potential implications of this for employers. So I've given you an example here. Rachel is 45, she's paid £25,000 a year. A contract requires 37.5 hours a week plus extra hours as are needed, but she works an extra 30 minutes Monday to Friday, so every one of her working days, and she doesn't get paid overtime for it. Well, the question I've posed, and I've kind of given you the answer underneath, is will she be paid enough on the 1st of April 2025? Well, if you say, well, this is a salaried contract for 37.5 hours, therefore she's only due £23,809.50, you'd say, yes, she's certainly paid enough. However, if you factor in those extra 30 minutes a day, that takes you up to 40 hours. And if you count all of those, then she is definitely not paid enough. Over £25,000 would be due. So why am I highlighting this? Well, the key thing to realise with national minimum wage is there are 4 different methods of calculation, and you have to choose the right one for each employee. The 2 that often get confused is the top one and the bottom one on my little list here, so salaried hours versus unmeasured work. Unmeasured work will include a fixed sum that is paid regardless of working days in the month, and it will also cover when there is a contractual obligation to work such additional hours as may be required, or words to that effect. Now, with people who are paid an annual salary, paid the set sum each month, it is also not uncommon for them to have wording in the contract that says your normal working hours are X, but you may be required to work such additional hours as may be required for the proper performance of your duties, or similar. If you have either of those scenarios, it will be unmeasured work and not salaried hours work. And that means that every hour worked in the pay reference period would count towards that national minimum wage calculation. There is an exception if you have a daily average agreement in place, which is a bit outside the scope of the session today. But it's crucial you get this right, because ultimately if you don't, there's penalties, there's naming and shaming, there's even potential criminal liability for willful refusal, amongst other things. Now, the example I gave you on Rachel, she was only working 30 minutes extra a day. However, if you had an employee who was regularly working 1 hour, 2 hours or more a day, which is quite possible in some roles, then that could have a serious and dramatic impact on the level of national minimum wage that needs to be paid out. So your action points, you need to do a little bit of an audit, identifying those that are potentially at risk. Don't just think about those on hourly rates. Don't just think about those at the right bottom end of your sort of salary range. Just bear in mind that those additional hours could bring other people into scope. Ensure you've got that correct method of calculation. As I say, it is crucial, and it will differ depending upon the employee. Check those additional unpaid hours for those sort of perceived salaried workers. And then you have the normal obvious things, checking rates, tracking ages to making sure you don't fall foul at a basic level. I've then put on the slide, just for completeness, a couple of other things to think about if you are doing that audit. It's just remembering overtime and shift premiums won't normally count towards national minimum wage calculations. Salary sacrifice benefits also won't count. Accommodation will only account, so if an employee, for example, gets free accommodation as part of their role, that only accounts up to a quite small set allowance on a daily rate. And if you're making deductions, for example, someone has to have a uniform for their role and you make deductions from their salary, you need to take that into account in your national minimum wage as well. Right, change in tax slightly, which is the third thing I'll talk about in this part 1, and then we'll save the rest for the other sections. But what we are seeing in 2025 is some organisations are rushing or at least advancing some organisational changes in advance of some changes that are likely to be due in 2026. And those changes concern two things. One is an ability to change terms of employment for existing employees, and two is some changes relating to collective consultation. Now, this essentially stems from the Employment Rights Bill, which you'll have seen a lot of publicity about. It's progressing through Parliament. It may be subject to further change, and there's still some uncertainty on the timelines. But ultimately, what I've tried to do here is set out, in summary, sort of the current legal position or some of the current challenges with change in terms of employment in particular, and then I'll go on to talk about how these changes may make it more difficult. So the first starting point for these things is that if you want to change an existing employee's terms of employment, it is a contract, and to change a contract, you need consent. You can't do it unilaterally. There needs to be an agreement. Now, the best way to do that is to have express agreement. So you have a written variation, you have a new contract, but essentially the employer and the employer agree that a change is going to take place. The alternative, which is much more risky, is some employers will rely upon implied consent. So they will make the change and hope that the employees, in continuing to work and not bringing a claim and not raising a grievance, will have impliedly accepted the change. If you can't get consent, your alternative, as things currently stand, is a practice that is sometimes called fire and rehire, which is where you consult with the employee about the change, you consider what they have to say about it, you consider the business importance of it, and you reach a stage where you terminate the employee because you say, we need to make this change, it's sufficiently important, we've listened to everything you have to say, but it has to be done. And you immediately offer re-engagement on the new terms that reflects that change. So that's one way of going about it. However, what that leads to is, or can lead to, is collective consultation issues. So if you are proposing to dismiss 20 or more employees in a 90-day period at a single establishment, which for current purposes normally means a single place of work, by reason of redundancy or because of fire and rehire terminations, which are classified as redundancies for these purposes, you have to do collective consultation, which is a formal process to be followed with union representatives or elected employee representatives, and you have to follow that process. Obviously, with all of these things, if you are dismissing people, you have risks of unfair dismissal claims. If employees have over 2 years service, as things currently stand, you would need to establish you have some other substantial reason for dismissal, which you can do on a change of terms. You have to establish you have a sound business reason. It doesn't have to be crucial for the survival of the business, and you have to weigh it against the impact on the employee, but potentially it's a fair reason for dismissal, or it might be a redundancy situation. You've got a code of practice on dismissal and re-engagement that came in, or a new one came in July last year. As of the 20th of January this year, you've got a potential adjustment in awards if there's a failure to follow that code. And also, in some extreme circumstances, there might even be an implied term in a contract, as there was in a Tesco case last year, that actually that term is a permanent feature of the employment arrangement, and therefore you can't change it through fire and rehire. The reason for highlighting it is really to try and explain that even as things currently stand, these types of changes, making changes to terms and conditions, is not that easy. However, it has got a lot of bad publicity. The P&O case a little while back certainly brought about a demand for some changes. And in the next steps to make work pay document that was produced by the Labour Party, that's where the quote at the end comes at the end of this slide: end fire and rehire by closing the loopholes which allow firms to engage in these unscrupulous practices. So how are they doing that? Well, in the Employment Rights Bill, we have a new potential automatic unfair dismissal claim. So if the reason or principal reason for a dismissal is that you have sought to change terms without agreement, or it is to enable the employment of somebody else, or re-engagement of the employee under varied terms for substantially the same duties, it will be automatically unfair. So in short, all of those fire and rehire situations I highlighted, they would fall within that as automatically unfair. It applies to express and implied terms, which is something you have to be careful of, not just those written terms in the contract. You can have implied terms of employment, maybe under a handbook, maybe through custom and practice. And because it will be automatically unfair, there would be no qualifying period. So day one rights, essentially. So there is a very limited exception to something being automatically unfair as and when this gets enacted. And that would be if the terminations are to eliminate or significantly reduce the effect of financial difficulties. Those financial difficulties are in effect at the time of termination or in the immediate future. And those financial difficulties are affecting the ability to continue as a going concern. And the employer could not reasonably avoid the necessity for those terminations. So you've got a need to resolve financial difficulties or significantly reduce them. Those financial difficulties need to be a live issue. It can't be something that is speculative or in the distant future. And they have to be so serious that they might be impacting on the ability of the business to continue as a going concern. There's a similar but slightly different test for public bodies, I should add. If you meet the terms of that exception, which will be quite difficult, I would suggest, you then still have normal unfair dismissal rules, which would include a consideration of consultation with the employee, consultation with representatives or a union, and an analysis of the process you've followed. But in short, these changes, if they're effected as they currently stand, will make it much more difficult for employers to utilize fire and rehire for any change to contractual terms unless there is a real significant risk to the business. So that's the third thing I talked about, changes. Second one I want to flag up is collective consultation changes. So my backdrop to this slide is lovely old Woolworths, which closed in 2011. And led to some case law that is still currently relevant, but is potentially about to change. So when Woolworths closed, there were about 4,500 employees who were engaged at branches with less than 20 employees. And what that meant is that those employees were not entitled to be formally collectively consulted about the redundancy situation and were not entitled to a protected award, basically compensation for failure for that process to be followed. And that's because of the establishment test, which I highlighted earlier on. So this idea that if you have 20 or more redundancy proposed in a 90-day period at a single establishment, then you have this obligation to collectively consult. The law as it stands is that that establishment test is part of it. So because these employees were at Woolworths with less than 20 employees, they weren't protected. The proposal on the Employment Rights Bill is that is removed, and instead the test would apply across an employer entirely. So 20 or more across the entire workforce of the employer. There's also a proposal to potentially increase the protective award to either 180 days or even make it uncapped, and a right to claim interim relief, which is, in simple terms, the ability of an employee to remain in employment until such time as their case has been resolved. Also a suggestion that they might extend the minimum period for consultation for redundancies of 100 or more. So what are the issues with these potential changes? Well, we wait to see, obviously not yet to be passed, may not be passed till next year. There is a suggestion that it might lead to two-tier workforces, more difficult to harmonise terms. So you might have legacy employees on different terms to new employees. Will employers build in greater discretion and flexibility into their contracts to try and avoid having to change terms in future? Do we see different ways of trying to achieve financial savings? Is there an impact on productivity because it's more difficult to change working patterns, shift patterns, other things that might make businesses more efficient? From a practical perspective, monitoring the number of redundancies will become more difficult. You're not going to be doing that at each workplace, each establishment. You'll be having to do that across the organisation. It is a criminal offence not to file a Form HR1 with the Secretary of State as well. So it's not something you would want to get wrong. There is also a risk, I think, the collective consultation itself could be undermined if it is enacted as currently envisaged. The reason I say that is that you could have a very large employer, multi-sites, many thousands of employees. They have 20 redundancies completely unconnected at 20 different sites. That would trigger collective consultation, but those employees may have nothing in common at all. The reasons for redundancy might be completely different. Obviously, very different from the Woolworths scenario, where some employees were not included in collective consultation just because of the number of employees at their place of work, obviously all still linked to the financial issues Woolworths had at the time. And then, yes, delays and staggering difficulties. You've got minimum periods of time for collective consultation that has an impact upon how quickly you can make these changes. So, what are your action points taking into account these potential changes? Well, the first thing is you really need to ensure your contracts are in good order. Ultimately, you need to ensure they're comprehensive so that they are covering everything and are also clear what is contractual and what is not. They also need to be well drafted, because if changing them is going to be difficult in future, you're going to want to make sure they're in good order on day one. You might want to look at your discretion relating to benefits. Have you got enough flexibility built into those clauses? If you want to change provider, if you want to withdraw a benefit, have you reserved those rights? You might also think in practical terms how you can demonstrate discretion is being exercised. So yes, you can have clauses in the contract, but annually, are you reviewing those benefits or those clauses and communicating to your employees what your decision is? Do you want to build more flexibility into your contracts, and whether that's on specific things like place of work or a more general flexibility clause? If you're a large employer, you might need to consider whether you want union recognition or a standing body of employee representatives. You are going to have to, if things come through as planned, be doing collective consultation a lot more. You might want a standing body of representatives so that you don't have to constantly be running elections or working out who you're going to consult with each time. In theory, you could have multiple companies, multiple entities to try and reduce your collective consultation obligations, because it is judged by each employer, so it would be each company rather than the full corporate group. I suspect that comes with many other challenges that would probably outweigh the disadvantages, the advantages. You can think about how you're tracking redundancies, including those contractual changes. Do you want more fixed-term contracts? An expiry of a fixed-term contract is a dismissal for most purposes, but it doesn't count towards your collective consultation numbers. And then the final thing I would say is, obviously, you can think about making changes now or before these changes come in, but it is still not easy. You still have to comply with the law as it stands. And obviously, we don't know if these legislative changes will be watered down or changed before they passed. You don't want to do something in haste and regret it. So that's the end of part one. Obviously, there's two other parts for you to view, talking about the changes that are coming up. It is only a summary. Please do take legal advice on your specific circumstances. If you want to subscribe to get details of our webinars, our updates, future events, then please do drop me a line or give me a call, and we would be happy to add you to our lists. Thank you.